Recording in progress.
Only Chairperson.
Morning, Mr. Matonsi. How are you?
I'm okay, Chairperson. We have enough members to start with the meeting. We have officials from the department and also from the IEC. If we can start with the meeting, Chairperson. Over to you.
Thanks very much, Mr. Matonsi, and welcome. Greetings, honorable members. Greetings, the leadership of the IEC and the Department of Home Affairs. We've now received all the reports as we've indicated in our last meeting that will ground ourselves to deliberate on the clauses. We've requested the content advisor to draft a framework that will guide us on our deliberations. We'll also note some of the issues that both the IEC and Home Affairs will respond or comment if clarity is sought by members after the deliberations, so that we're able to take decisions on all the clauses that are entailed on the amendment bill. I will not waste time to invite Mr. Matonsi to formally on item number 2, if there are apologies, and if there are, to introduce the team, as we have indicated that all the stakeholders are in attendance, including the Parliamentary Legal Services and the Chief State Law Advisors, and the Home Affairs and the IEC. Is there any other matter that you want to render, Mr. Matonsi, on item number 2? I think also must note that the Select Committee of Justice and Security will not join us now that we're deliberating, because the same deliberation, they still have to, the amendment bill still have to be referred to the committee. So they will have enough time also to look on some of the issues that the committee might have or could have looked at. Mr. Matonsi, can I invite you to deal with item number 2?
Yes, Chairperson, from my side, I've got an apology from Ms. van der Merwe. She indicated that no, she will be joining us on the second round, which is around 2 o'clock. She has got some urgent stuff that she's dealing with. The other apologies are from the Minister and the Deputy Minister. That's all from my side, Chair.
Thank you very much. Any other apology from Parliamentary Legal Services?
None from our side, Chairperson. Tulana Halley. I'm Tulana Halley and I'm representing Parliamentary Legal Services today.
Thank you. State Law Advisors?
Good morning, Honourable Chair. No apologies. The entire team from the Office of the Chief State Law Advisor is present. Thank you, Chair.
Electoral Independent Electoral Commission?
Good morning, Chairperson. Good morning, honourable members. I do have apologies from the Chairperson of the Commission, Sutumoepia. He is travelling at the moment for the Commission. I am joined by other commissioners, including Dr. Masuku. We will have the other two commissioners joining us during the course of the meeting. Chairperson, in addition to that, we're joined by the administration led by the CEO, and we have guests with us today who have come to meet with the Commission in order to discuss political party funding related issues. Chairperson of the Sierra Leone Political Parties Regulation Commission, PPRC, Mr. Bangura, is with us today, and he's joined the CEO in listening to the meeting. Thank you, Chair.
Thank you very much, and also welcome your guests. Home Affairs? Home Affairs?
Good morning, Chair. It's Advocate Kumalo. I'm also having Advocate Malakate. I think the DG has joined or is going to join us, so we'll be with the DG as well. The Minister won't be with us today, Chairperson. Thank you so much, Chairperson.
Thank you very much. All welcome.
Thank you, Chair. I'm here as well. Thank you. Good morning to you and honorable members.
Thank you, DG. Thank you, colleagues. All members are welcome. Apologies noted and accepted. We'll now move to item number 3. We'll invite the content advisor to brief us, and then we then move to items that must be deliberated on. Mr. Sama?
Thank you, Chair. I'm just going to share my presentation. So, Chairperson, just to indicate again that we have submissions and responses from the DHA, IEC, and Parliament Legal on 14 of the clauses related to the bill. The first of those is relating to the definitions clause, in particular the definition of independent candidates and independent representatives. And then that's for the Party Political Funding Act, and then also the definition of donation and donation in kind, which is in the Act but not in the bill. And so the suggestions we have here, firstly, the submissions were that the definitions of independent candidate and needed to exclude party membership as a disqualifying criterion, and that the bill's definition of an independent candidate excluding party membership is in contradiction of the definition in the Electoral Amendment Act. And thirdly, that the Multi-Party Democracy Fund title didn't need to change. And lastly, the donation in kind should also reference independent candidates. And there was general consensus on all these from the IEC, the DHA, and Parliament Legal. For ease of reference, I've color-coded each of the responses. So the DHA is in red, Parliament Legal is in blue, and the IEC in green. And so they all agree that this definition, that there needs to be a more clear definition. So the independent candidate it means a South African citizen contesting an election in terms of the Electoral Act and who is not nominated on a list of a party. And independent representative means an independent candidate with representation in the national or provincial legislature. And then donation and donation in kind should reference independent candidates in the bill. And then lastly, reference to independent candidates and independent representatives should also be made in section 10 and independent candidates in section 14. But those we deal with later, so we don't have to debate those here. And then lastly, the DHA and IEC agree that the change of the name of the fund is not necessary and that its intention is clear. So essentially no need for a real debate here, just indicating that there's consensus on the need to change the definition. Over to you, Chairperson.
No, thanks very much, Mr. Salmon, for the brief. Is there any other members matter on the clause 3? We've taken note that all the presentation we made, and also we've dealt with some of the issues in the previous discussions when we're dealing with the Electoral Amendment Act. Can I invite hands for comment on clause 3 so that we move to the second one? Mr. Matons, you'll assist me to note hands. My gadgets here is a bit problematic. Comments on clause 3, members, on the definitions?
Chairperson, we do have one hand at the moment, Mr. Pillay.
Okay, thank you. Honorable Pillay.
Thank you very much, Honorable Chairperson. Chair, I support that clause, but I wanted to also suggest as a way forward and a sake of progress that wherever we have to include the term independent for mere reasons of it being a new word having to be added. So it was always political parties and now we're adding independent. That we agree that across all of the clauses where that needs to be added, we should agree that it should be added. I mean, I don't see any challenges with that. It's just going to help us move faster. Thank you.
Okay, thank you. That's a submission, members, and also the addition in terms of the framework of the presentation. I mean, the document that has been shared. Any seconder to that?
Lekwasa seconds, Chair. I don't see a problem with what has been proposed by Honorable Pillay, and I second the inclusion of the word independent where it's necessary. Thank you very much.
Thank you, Honorable Jose. I take it there's consensus on the clause 3 on the changes. Mr. Adam, we're carrying that. Can you move to a second one?
Chairperson, before you move, there's a hand from Parliament Legal Service.
Oh.
Sorry, Chairperson, it's Talana. I do understand what Honourable Pillay and Honourable Lekwasi are suggesting, but in certain instances, there would be parts of the Act where independent candidates need to be used, but not independent representatives. As you know, there's a difference between a political party and a represented political party. So I think that's where the confusion happened when the draft was sent to this committee at first, because there were certain instances where you didn't have to use the term independent candidates, but you could use the term independent representative. So I understand the need for speed, but let's also be mindful that the terms aren't used interchangeably. They have different bearings.
No, I think that is understood, Telana, by members. In principle, suggests that we're required to, in terms of the definite clauses, where you must insert that independent candidates. within the framework in which you have highlighted. This matter arose in our last presentation when Home Affairs was dealing with the matter, and also yourself as a legal team. I think in principle that is how we must interact with this matter. Is that understood, Telana?
Yes, Chair.
Okay. Thanks, members. With those notes, can we move to the second clause?
Yes.
Thank you.
Yes, Chairperson. Okay, so the next clause is clause 7, which is primarily dealt with under clause 29. So we won't discuss it here, but just to say that if in clause 29 it's decided that there doesn't need to be an equitable allocation but only a proportional allocation, then this reference here on 3A highlighted will need to change to refer only to proportional. Which would be a substantial change. This is argued later. So we won't debate this here. We want to put all the clauses in order. Then the next clause is clause 9, which deals with the use of funds, and in particular provided that donations or not be used for personal use or to cover legal costs against a political party or independent representative. And the submissions, you'll be reminded, are that that section 3D highlighted there unfairly restricts political parties' ability to cover legal expenses. Currently, political parties are prevented from using funds to defray internal party political disputes, and that this existing ban on internal party disputes be retained and that the parties be excluded in the section 7.3d. And that the prohibited use and allowed uses of donations should be equally applied to political parties and independent candidates. And that the PPFA only refers to legal costs relating to internal party disputes and makes no mention of litigation against a party. So the IEC suggests that the primary purpose of the section is to prohibit the use of money for inter-party disputes, and this must be clearly expressed, and that this should be removed from the bill as is contradictory and the object and purpose of the earlier paragraphs. And the provision should be extended to prohibiting garnishee orders against the money held by the funds of the Electoral Commission. So the DHA agrees with the removal of or to cover costs related to any litigation against the political party or independent representative must be removed. However, Parliament legal believe that the adding of garnishee orders to this as a prevention of usage is a substantive submission and would require further investigation and perhaps additional call for public comments. And also that the legal arguing that the attempt by the drafter to create a clause to prevent independent candidates from using funds for internal legal fees. However, independent candidates never have internal party disputes as they are one person. And so they agree that the section should be deleted or redrafted. Just for clarity section. So essentially, there's agreement that this reference needs to be removed, but disagreement on whether garnishee orders should be included as a prohibited usage. Over to you, Chairperson.
Thank you, Mr. Adams. Members, can I invite you to comment on the clause 9?
Chairperson, there's Honorable Stephen Swart and Mr. Ross.
Honorable Swart and Mr. Ross. Honorable
Good
Swart.
morning, Chair. Good morning to the colleagues and all the entities that are represented. Could I ask that we just look again at the previous slide, which I think was 5 or 6, that referred to the formula. I didn't quite understand the submission there that that maybe we can just reconsider that. That I understand that there would need to be an amendment if there was a removal of the equitable part, but that would be direct contradiction to Section 236. So I'm not sure, are we just getting a brief now on what it would require, which would be not only substantive, but would probably be very unconstitutional if it was to change. So I just wanted to flag that issue with a big question mark there, given the fact of Section 236, which requires an equitable allocation as well. Thank you, Chair.
Honorable Short, are you done?
Yes, I am. Thank you, Chair.
Honorable Short? Mr. Matonzi?
Yes, I'm done, Chair.
Is
Can you
done,
hear me?
Chair.
Okay, thank you. We'll note that.
Thank you.
Honorable Pile?
Thank you,
Sorry.
Chair.
Sorry.
Thank you, Chair. So first of all, with this one, this 6.3a, Chair, I understand there was a submission to consider essentially doing away with the equitable portion, so the 0.25 proposal. My understanding is that we as a committee had sort of said that that's not desirable, but maybe I'm misread that. But I also want to just confirm that there is an equitable portion required in terms of Section 236 of the Constitution. So we wouldn't be able to remove that, Chair. And then on the next section as well, I think the other aspect to look at when you now deal with an individual, I think the important thing to guard against here as well is that
Mr. Ross, Honorable Ross, can you properly find a good space? You are cutting. And you can't locate.
Okay, check. You hear me now?
Yeah, can hear you now, Honorable Ross.
Thank you. Yeah, so I think the other thing to be careful of here is that if the funding is received, the proposal to cut the wording off of 7.3d at personal use really covers a lot in terms of specifically independent representatives, because you don't want a situation where public funds can be used that is meant for political party or let's say political activity and the development of democracy to be used for personal legal expenses and things like that. So we agree with that, cutting it off at the end of personal use. The issue of garnishee orders, we've already got a clause in here that talks about the non-attachment of funds in the democracy fund. And we truly believe that unless substantive changes are absolutely necessary, then we should avoid them at all costs and deal with them as soon as possible after the election. Thank you, Chair.
Thank you. Any other hand?
No other hands, Chair.
Okay, thank you, Mr. Matonzi. Mr. Adams?
Thank you, Chairperson. So the next clause is clause 11 on prohibited usage, where the submitters argue that that reference should purely be made to the Prevention and Combating of Corrupt Activities Act.
Adams, sorry, Mr. Salmon.
Yes.
I don't know what you did on your side, because
Yes.
you are disrupting your presentation.
I don't understand, Chair.
It's on my side, Mr. Matonzi?
I think it might be you, Chair. We could hear Honourable Roos quite clearly earlier when you were saying he was being disrupted.
Yeah. Well, that's better. Yeah.
Okay. So if I can proceed, the submitters argued that the reference should just purely be made to the Prevention of Combating of Corrupt Activities Act. Also that training from funding from foreign entities should be available for support staff of independent candidates and independent representatives. And that the bribery prohibition falls short of the international law requirements. Parliament Legal indicate that the donation and donation in kind specifically cover money, assets, services, and to paid or lent to a political party, and now independent candidates, whereas PRECA Act considers a gratification, and so the inclusion of PRECA would be misplaced. But and so this is a policy decision, but essentially there's no the PRECA doesn't exactly overlap with this, so we shouldn't really be referring to it. IEC, the Commission view this as a consequential amendment and submits that training and development may be extended to support staff of independent candidates and independent representatives. The DHA submission, so we only just received this morning, so I haven't color-coded it yet, is that this is a consequential amendment and that independent candidates and representatives should be included. Yeah, so basically the DHA in agreement on that one. I can go back to you, Chair.
Thank you. Members, comments on the clause 9? There seem to be consensus in terms of the responses in submission by stakeholders. Mr. Matonzi, there's a hand?
Yes, there's Honorable Pillay and Honorable Ross.
Honorable Pillay and Honorable Ross.
Thank you very much, Honorable Chair. No, supported, Chair. Thank you.
Honorable Ross.
It's fine, Chair. I just want to double check here, though. Are we saying that we are going to extend the use of training and development to the support staff of independent candidates and representatives, but not of political parties?
Honorable Ross, can come in again.
My question is, with the IEC input. So it looks like we're saying we want to say that the training and development should be extended to their support staff. But would this then also be extended to the support staff of political parties?
Thank you, Chair.
Honorable Ross is cutting.
No, Chair, I think it's on your side. I heard him clearly.
Okay.
Chairperson.
Yeah, I was checking. Yes, can you proceed?
Yes, Chair. Chair, the inclusion here is to add the independent candidates and representatives. And my understanding is that it already exists for political parties, but perhaps we can just get clarity. Thank you.
Yeah, I think that is an understanding that already political parties are covered. But I think the IEC, because they will give clarity on all the issues that we've considered. I do not invite them now, but I think let's note that and we proceed. Unless it will cause confusions once they come back and invite them close, but when we deal with the clause and there's clarity that is sought, we can invite them. Will that be sufficient if we invite them when we have completed, or we can invite them by clause by clause? Can I get guidance from that so that we don't confuse members?
Chairperson.
Honorable Pillay.
Chair, there may be very few clauses that relate to IEC, and my proposal is that we bring them in when it is necessary, so that it just saves us having to go back through all the clauses again.
Okay, nice. Thank you very much. Can I invite Commissioner Love?
Thank you very much, Chairperson. The current legislation makes it very clear that the donations received can be used for the training of any member of a political party. So unless the Honourable Member Roos is suggesting that support staff are not members of the party, I think that the political parties are adequately covered as the Act exists at the moment, Chair.
Yeah, thank you very much. I think that is the Honourable Roos, are you covered?
Yes, thank you, Chair.
Okay, thank you very much. for that intervention, Commissioner Love. Mr. Adams, can you proceed?
Thank you, Chair. And so I believe we have consensus there. Yes. Then moving on to clause 13. This is on the disclosure of donations. The submitters indicated that an amendment should be introduced requiring companies and trusts to disclose their beneficial ownership information when donating to a party or independent to make sure that there's clarity of where the donations come from. They indicate that reliance on what the intention of the donation is difficult to police. There's argument that the Executive Ethics Code was unconstitutional in a court case, given the lack of requirement to disclose donations to inter-party election campaigns, and that this principle should be equally applicable to parties and candidates. And then lastly, that the disclosure threshold should be removed entirely and donations to be disclosed. So there is reference to threshold in this clause, although the actual threshold is dealt with elsewhere in the Act or in the bill. And so if the threshold argument decides that the threshold should be removed, then this clause will need to change its reference to the threshold. The IC view these as substantive submissions, and therefore they should be deliberated by the committee or new parliament with policy consideration by the DHA. The DHA also, I received this submission this morning, was that the DHA do not agree with the suggestion of introducing a new clause requiring companies and trusts to disclose their beneficial ownership information. This is beyond the purpose of the Party Political Funding Act, and the issue of inter-party donations is not covered by the PPFA and should not be included, or we have the view that this should not be entertained at this stage. So yes, so we have those two submissions.
Thank you, Mr. Adams. Members?
Chairperson, there's Mr. Ross.
Honorable Ross.
Thank you, Chair. Chairperson, I think that the DA has a general view in this regard with a number of these substantive changes, in that we need to take the Political Party Funding Act and produce a report on its impact. What has the impact been for the parties? What has the impact been for funders, etc.? That can advise these kind of things, all of these kind of substantive changes, the percentages of allocation, etc., etc. So it's the same in this case. So I agree with what the department is saying, is that we shouldn't include this at this stage, but it can be part of a review of the Political Party Funding Act, and then we can look at it in the next term. Thank you, Chair.
Thank you, Honorable Ross. I think we must be able to isolate subject matters for discussion, because if my understanding that is a strong argument in terms of the political party funding, which is a subject matter that the committee will deliberate on. But at this moment, we may need to, on clause 3, in terms of the subject matter, the committee guides whether we concede on looking on this matter beyond this 6th Parliament, or the committee may, or the new committee that will be dealing with Home Affairs, look on this matter in the next Parliament. Is that an understanding of the process? And that is a submission. I get a sense that you agree with the proposal that has been carried by both the Home Affairs and the IEC. Any seconder to that, or any other view that Honorable Ross has raised?
Chairperson.
Honorable Pile.
Chair, I've noticed that you can't see the hand, so I'm going to just call out if it's okay with you.
That's why I requested Mr. Matonzi, and I think it's not assisting me. Sorry, members, I'm struggling here. I indicated to Mr. Matonzi that he must assist me with the hands. But Chair, you can keep...
Yeah, Chair, I think you've summarized correctly, and I second your proposal that it can be a matter for the next administration. Thank you.
Okay, thank you. Can you proceed, Mr. Salmon?
Thank you, Chair. Clause 14 deals with the donation prohibitions, and the submitters indicate that repeated alliance and intention, again, like clause 13, would be difficult to police, and that the independent candidates and representatives should be included in this to prevent them from having undue influence. The DHA agrees that the independent candidates and representatives must be included in this provision for certainty of oversight. Parliament agrees with the inclusion of the new section 10(1), 2, and 3, as it provides no person or entity may make a donation to a political party with the expectation that the party or member influences an award or a tender. However, independent candidates should be included in the provision. What is concerned is that there's no legitimate reason for the deletion of the original section 10 of the Act, which prevented any person or entity from delivering a donation to a member of a political party other than for political party purposes. Legal disagrees with the DHA's explanation that the original section 10 criminalizes members of a political party when they receive gifts for the following reasons. Donation and donations in kind is specific to money, services, and assets for and to be used by political parties, and donation in kind is not a gift. This is a very wide interpretation of the definition. And gifting would only be a donation when it is for the use of political parties, and should a donation be given to a member and that member does not use it for political party purposes, only then are they in contravention of section 10. So essentially what legal is arguing is that that there should be inclusion of representatives, independent candidates in this section, but that we shouldn't remove the original reference to donations and gifts in section 10 of the Act, just to be more specific. I'll allow Talana to add if I've misunderstood this one. But essentially there is an agreement, just that the original section 10 shouldn't be removed, should rather be revised to include independent candidates and make reference to donations rather than gifts. Thank you, Chair.
Thank you. Members?
Chairperson, Mr. Ross, his hand is up.
Honorable Ross?
Thank you, Chair. Chair, I believe we agree with Parliamentary Legal's interpretation of this. Clause 10 should stay as it is, apart from the addition of independent representatives, etc. Because what you do here, once you create an opportunity for some sort of a personal donation to somebody, then that also counts for an independent candidate. And then you have to make provision for how do you record that and what are the values, etc. So it hasn't been considered in the Political Party Funding Act at all that an individual could receive a donation for themselves. And so then you have to go and say, what are the limits? How do they get policed, etc., etc. So the DA is saying we should leave section 10 as it was and just include independence in there in terms of not being able to receive a donation for themselves. Because essentially what you're doing here is you're adding not for the reason of a tender, license approval, etc. Whereas currently it says you cannot do it, and it's a much more stringent requirement. Thank you, Chair.
Thank you, Honorable Ross. And other member contributions?
There's Honorable Pillay.
Honorable Pillay.
Thank you very much, Chair. Chair, I think this is also related to previous clauses, and it all relates to political party funding. And I'm of the view that we leave it the way it is, and that we add independent candidates and representatives as indicated prior, and that if there's a need for anything else to change, that will obviously come later on. But as it stands, it should remain the way it is. Thank you.
Thank you, Honorable Pillay. Any other contribution? Thank you very much, members. Mr. Salmon, that is carried. Can you proceed?
Thank you, Chair. This is clause 17 relating to reporting obligations of a party. And the recommendations are there that a person intending to contend an upcoming election as an independent may register their intention to do so with the Commission at any time after the preceding election. Further, inform the Commission of the vehicle that they wish to campaign under, as in like their banking status, essentially, or company status. From the date of registration, the independent candidate should be treated equally with registered parties for all purposes, including campaign, taxation, and disclosure. The IEC agrees that the Act should be amended to include a clause that provides for registration of intentional or aspirant independent candidates at the time when their intention is made known. And the parliamentary legal indicating that this should actually make reference to the Electoral Act, not to the Party Political Funding Act, in terms of the registration of intention to run. So there's just a correct reference there. So I think the correct reference is clause 3031. And so it shouldn't actually refer to the PPFA, but rather to the Electoral Act. That's that, Chair.
Thank you. Members?
Chairperson, Honorable Pillay and Honorable Ross.
Thank you, Honorable Pillay.
Thank you very much, Chair. Chair, I am in support and agree that it should be referred to the Electoral Act and not PFFA. Thank you.
Thank you, Honorable Pillay. Honorable Ross.
Thank you, Chair. I think when we discussed this originally, we did concede that it's quite a difficult one. You know, if you have independent candidates that, yes, they must open a separate bank account, but now they get fully taxed on income as it's their own. So the DA is certainly open to what the submitters have argued in terms of independent registering their interest to contest, and then indicating what their financial vehicle will be so that they can manage that electoral funding in the most tax-efficient manner. So the DA does agree with that. And then also the reference to the Electoral Act. We agree with that as well. Thank you, Chair.
Thank you, Honorable Ross, Honorable Pillay. Mr. Adam?
Chairperson, sorry. There was another end, Mr. Mukhale.
Honorable Mukhale?
Thank you very much, Chairperson. Yeah, I think we agree with this, Chair, that there should be a disclosure by all independent candidates and political parties who intend to contest. Thank you.
Thank you.
Chairperson, before you move on, there's a hand from Ms. Love from the IEC.
Okay. Commissioner Love?
Thank you so much, Chairperson. I wonder whether I could allow through you, the CEO to come in, because I think that the idea of incorporating this in the Electoral Act is probably missing some of the issues that we're trying to raise. Would you allow that, Chairperson?
Yes, CEO.
Thank you.
Thank you, Commissioner Love, and thank you, Chairperson of the committee. The point that we wish to raise is that the idea that we should have a register of independent candidates as we do for political parties, I don't think that is necessarily an optimal approach to take. What the suggestion we're making sought to do was that in terms of the party funding regime, if a prospective independents have reached the decision that they wish to take part in the election, they need to serve notice of intention to contest, whereupon the reporting obligations then arise. So it's essentially an innovation related to the party funding regime, as distinct from the Electoral Act regime. There need not be a list of registered independent in the same way as there is for political parties. But once an individual says, I'm going to be running in 2029, they serve as notice of intention to contest. From that moment on, they are then subject to the reporting requirements that we are contemplating in Section 12, capital A of the bill. Thanks. I just wanted to clarify the point that the Commission is making. Thank you, Chairperson, and thank you, Commissioner Love.
Thanks, Commissioner Love. Thanks.
Thanks, Chair. If I could just add, I think what we also, the critical issue is to avoid retrospectivity. So if somebody decides to run for an independent in 2029, if they, at that point, try and raise funds for that purpose, they do it knowingly that they have the obligation to report. We don't impose any or attempt to impose any retrospective obligation. Thanks, Chair.
Okay. Thanks very much. I think that's offered more clarity on the Mr. Adams.
Yes, Chairperson. We'll just ensure that the technical reference is correct in the A list.
Yeah.
The next clause is clause 18, dealing with independent bank accounts. And the submitters grant that tax exemptions allow diverse persons and diverse campaign structure juristic options should be allowed for independent candidates, not just sole proprietor, as is suggested by the reference to their own personal bank account. They also indicate that the section ignores operational and financial requirements of running a campaign as an independent candidate, and suggests that Section 12(1)(b) should be amended to ensure that the personal accounts of independent candidates are separate from the use of donations. And the legal section proposal is that 12(a)(1)(b) should provide that independent representatives must keep a separate bank account with a bank registered as a bank in terms of the Bank Act, into which all money allocated to him or her from the funds must be deposited, and the DHA agrees. The IEC agrees, saying that this is consequential, and as they need the IECs need to declare their donations as soon as their intention to contest is made known, as the CEO just indicated. For the upcoming elections, the IEC will be required to make declarations upon certification as independent candidates. So there's general consensus there, Chairperson. No need to make a decision unless members have something to add. Thank you.
Don't say there's no need for members to comment, Mr. Salmon. It's the important proceedings we're dealing with. If members have different view, the views must be on record. Can members comment?
Chairperson,
Yeah.
Mr. Ross at Besipile.
Honorable Ross, please.
Thank you, Chair. It's just to double clarify again. I think that the DA's position is to say it shouldn't necessarily have to be a personal bank account in the independent's name. That it should allow for the registration of a bank account or something under a juristic person, as long as that is registered with the IEC, as per the input on the previous clause. So just to make that clear, our position is not that the person would have to get a bank account in their own name and be subject to that tax regime. They should be able to choose a juristic person, etc., for the purposes of recording their party funding incomes and outgoings. Thank you, Chair.
Thank you, Honorable Ross.
Thank you, Chair. Chair, I think the important point here is that they have a separate bank account. I think you can't allow for a joint account, because that means that you're going to obviously be looking at your your personal account and your party as an independent. So for me, it would be that it has to be a separate bank account, and that I support. Thank you.
Thank you. Any other member? Mr. Matonzi?
There's no one. No one has raised their hand.
Okay, thank you very much, members, for the comments. That is carried in terms of the express view of the separate account.
Thank you, Chair. The next clause is clause 19 on the repayment of unspent money. And the IEC indicate that the Commission agrees that the clause is consequential and to only independent representatives, and that the new section 13A of the PFA should apply only to independent representatives and not political parties, because political parties can still use the funds for their remaining members, whereas independent representatives have no other members which to hand over their unspent money should they be removed in some way or pass on, or so there's general consensus, or there was no further opinion other than from the IEC.
Okay, thank you, Mr. Salmon. Members?
There's a head from Mr. Lehwase, Chair.
Honorable Lehwase?
Thank you very much, Chair. With the reasons provided, I think the clause is okay as it is, and I would agree with it that the new section only applies to the independent representatives. Thank you very much.
Thank you, members. Thank you, Honorable Lehwase. Any other comment? Thank you, Mr. Salmon. We've carried, move to another clause.
Thank you, Chair. The next clause is clause 20, investigative jurisdiction of the IEC. And the submitters argue that to include independent representatives for consistency and to ensure equal oversight, and that there be consistency across the Act on independent candidate and representatives. This is also what members have indicated. That section 14.1 and 4 of the political party funding both refer to compliance only by political parties and independent candidates, but not independent representatives. The IEC and DH agree with the submission that section 14A of the bill only refers to independent candidates and not independent representatives, and the provision should be rewritten to ensure that there's no ambiguity. Parliament legal section disagree that the duty to monitor compliance by political parties, that the amendment therefore now includes all independent candidates, regardless of whether they receive a seat in the NA or the provincial legislature. Therefore, there's no need to include independent representatives. However, this section could be interpreted widely to mean that once an independent representative gains a seat, the provision does not apply to them. So I think just in the argument there that there should be clarity in terms of reference to independent candidates and representatives, and when they, in terms of who can be investigated and who can't. Chair.
Thank you, members.
Chair, there's Mr. Ross.
Honorable Ross, I'll also invite the IEC to comment on the clause 20. Honorable Ross?
Thank you, Chair. Chair, I agree with the IEC and DHA's approach to this. Let's just rather ensure there's no ambiguity. Bearing in mind that many people from political parties, people that are not legally trained, they might read a provision like this, and let's just make it clearer and include independent representatives as well. So I agree with that change.
Thank you, Honorable Ross. Any other member?
Chairperson.
Honorable Sorry, Honorable
No, it's fine.
Raise your hand, my brother.
No problem. The submission by IEC and DHA, I think, is sufficient, and I'm going to support that we do clarify that. Thank you.
Okay, thanks very much. I don't think, IEC, is there any other comment you want to advance for more clarity?
Chairperson, from my side, I do think that we tried to cover the issues clearly, but let me through you, if that is in order, ask the CEO if he would like to add anything. CEO, is that okay, Chair?
Yes.
CEO?
No, Chair, there's nothing additional we wish to bring at this stage. Thank you very much.
Thanks very much. Mr. Adams, Carrot, you can proceed.
Thank you, Chair. The submissions on clause 24 on penalties for contravening the Party Funding Act. In particular, that any person who makes a donation to a member of a political party instead of the party, but to a member of a political party instead of the political party concerned, to circumvent the provisions of Chapter 3 commits an offence for a fine of 200,000 rand or imprisonment for a period not exceeding 5 years. And the submitters argue that the bill should instead seek to streamline and standardize the manner in which political parties receive donations, empower the Electoral Commission to monitor bank accounts, and empower the Electoral Commission to refer any suspected breaches of the Funding Act to the NPA, and allow for the sharing of financial information about political parties' bank accounts held by the Financial Intelligence Center with the Commission. Then the further submissions were that only the maximum donation limit and the total donation limit would be subject to the factors listed in 24(1)(b). The disclosure threshold must also be subject to these factors in line with the memorandum on the objects of the bill, and the list of factors in clause 24(1)(b) should include the prevalence of public sector corruption and the importance of transparency for the exercise of constitutional rights, and that the President should be required to consult the Commission before making regulations affecting those disclosure thresholds or limits on donations. So, and that also the submissions that the equalize treatment of independent candidates and representatives with parties regarding permissible and prohibited donations. The provision of clause 24 appear to be wholly ineffectual without an enforcement mechanism, and the bill does not specify how donations are to be monitored and by whom. Legal services initially agreed with section 19(4) should include reference to independent candidates. However, close analysis appears that section 19(4) prevents a person from donating to a member of a political party instead of a political party itself. Legal now questions whether this would be applicable to independent candidates, as they are one person. There should always only be a donation made to an independent candidate and not to another person. The IEC considers this is substantive rather than consequential. If the view that the IEC's investigative capacity must be strengthened, the same must be debated in the new Parliament. Also, the suggestion that perhaps the reference made to Chapter 3 on the direct funding of political parties in the provisions should be removed. A further request that the fine amount should be removed from the Act and be placed in the regulations. Keeping it in Act will make it too onerous to adjust should the need arise. And the DHA, however, agree that independent candidates and independent representatives should be included in section 19(4) in terms of their investigative capacity. So the question really there is, should the reference to independent candidates being investigated or being investigated by the IEC be included, and how extensive should that investigation be? And if it needs to be more extensive, do we do it in this bill or do we debate it in the next Parliament? Thank you, Chair.
Thank you, Mr. Adams. Members?
Mr. Ross hand is up, Chair, and Mr. Pillay.
Honorable Ross?
Chairperson, we agree with the IEC's input in this regard, Chair. I think it really is one of those, again, where you need to have a proper report on the impact of the Political Party Funding Act to start to make recommendations and changes on this kind of thing. And I think it's something that needs to be done with a lot of consideration and should be done by the next Parliament, Chairperson. Thank you.
Thank you, Honorable Ross. Honorable Pillay?
Chairperson, I would like to ask for legal to give us clarity on their submission here. I must say I'm in support of what the IEC is saying, that it should be a matter for the next parliament. But I just want to understand what legal is trying to bring across in their point. Thank you.
Thank you, Honorable Ross and Honorable Pillay. Ligan, Telana.
Hi, thank you, Chairperson, and thank you, Honorable Pillay. If you look at 19.4, if Adam can just go over to, you can put the clause up. 19.4 says, any person who makes a donation to a member of a political party instead of the political party concerned to circumvent the provisions of Chapter 3 commits an offence. So the submitter had said, why is this section only pertaining to political parties? And initially, we agreed with the submitter. Of course, you'd have to bring parity and include independent candidates. But would there ever be a scenario where a person makes a donation to somebody other than a political, an independent candidate? An independent candidate doesn't have members of an independent candidate. However, you know, if it is to bring parity, then perhaps a redraft of the section should be done. You know, offhand, it could read something like, any person who makes a donation to any person, including a member of a political party, instead of the political party or an independent candidate concerned, to circumvent the provisions of Chapter 3. So it was just an issue of, you know, there would be no members of an independent candidate, so how would we bring parity to the situation? Or would a situation arise where a person makes a donation to another person other than an independent candidate? I hope I'm making myself clear.
Okay, noted. Honorable Pillay.
Thank you.
Chairperson, just listening to what Tilana says, I think makes perfect sense. And I want to suggest that perhaps we do then include that in order to bring parity.
Thank you, members. Any other member? Okay, you have
I'm in agreement, Chair.
Thank you,
I'm in agreement with the submission by the last submission of Honorable Pillay.
Thank you, Honorable Ross, Honorable Pillay, and Honorable Khwase. Ms. Adams, did you catch that correctly?
Noted, Chair. We'll include the correct reference and remove the substantive and not include substantive changes. Thank you, Chair.
Thank you. Proceed.
Clause 26 then deals with the granting the president the discretion in determining regulations. And sorry, Chair, there's a hand from Tilana. I don't want to move on unless if there's an incorrect reference.
Sorry, Chair, and sorry, Adam. I just wanted to make sure that we don't overlook the fine exceeding the amount. I know Honorable Roos mentioned that we shouldn't be dealing with substantive submissions, but I think the IEC have a very good point with regards to including an amount. Their argument is that if we include an amount, we're going to have to continuously amend the Act, whereas an amount like that can be included in the regulations. I don't want us to overlook that point and move on. I understand what Honorable Roos is saying about substantive changes, but I don't think that is I mean, in my opinion, I don't think that's a substantive change. I think it is important to create a fine, but when you start putting, as a rule of drafting, when you start putting amounts into legislation, you set yourself up for a fall because you continuously have to amend an act when there's inflation, you know, the economy changes. So just as a point.
The proposal is carried that it must be located in the regulations. That is an understanding of the submissions, Telana, for all members. I'm not sure unless I'm reading from a wrong note of submission by members, and that's my understanding. Is there contrary to that what the IEC proposed and what you have interacted members? So that we assist the. Okay. You understand that, Chalana?
Yes, Chair.
Okay.
Chairperson, there's a hand from Advocate Bongo.
Bongo?
Thank you, Chair, and good morning. I found the contribution from Telana to be quite a good one, and it's let us not put amounts into a legislation. I think regulation must take care of that aspect on the amounts. Thank you.
Thank you. Carried. Proceed, Mr. Adams.
Thank you, Chair. So the submission on the President's discretion on determining regulations, there was strong opposition to this clause, arguing that it undermines parliamentary accountability, and that advocating for full parliamentary control in delaying the clause until proper public participation on any submission on such amendments. The amendment to Section 24(5) of the Party Funding Act would render the current regulations contained in Schedule 2 of the Party Funding Act as unnecessary and introduce uncertainty. They propose various alternatives, such as extending the mandate of the Independent Commission for the Remuneration of Public Office Bearers, or including the Minister of Finance, or requiring the President to consider objectively measurable norms and standards from other democracies, or reference to the Consumer Price Index or the minimum wage. And legal section argues that it could be argued that the President has been assigned plenary power when he used to only act on the resolution of the National Assembly. Furthermore, there's no definition for minister referred to in the Party Funding Act, and indicating that it should be in consultation, not it should be after consultation, not in consultation, is problematic. The DHA and IC agree that in order to address concerns raised regarding the powers of the President to make regulations in Clause 26A, they suggest going back to the original formulation, which reads that the President, acting on the resolution of the National Assembly, may proclaim in the Gazette regulations in respect to matters contemplations in these sections, and together with these safeguards, that the amounts previously appropriated by the Acts of Parliament for the Party Funding Act within the previous financial year, and that the effects of inflation on the value of money over time and the costs associated with participating in a political party, independent representative candidates, and in democracies in South Africa, in our view, addresses the raised issues. And so essentially there's an alignment on the inclusion of the National Assembly in the President's decision on regulations, and that it must be it must be after consultation, not in to be after consultation, not in consultation with the National Assembly. Thank you, Chair.
Thank you, members. Can I invite comments on Clause 26?
Chairperson, Mr. Pillay hand is up.
Honorable Pillay.
Thank you very much, Chair. Chair, I think the part that includes the resolution of the National Assembly is sufficient, because that means that there would have to be the necessary steps followed. Consultation, there'll be the PC involved, etc., until it reaches that resolution. So I think that is sufficient and I support it. Thank you.
Any other member?
There's Advocate Bongo and Mr. Ross and Miss Moody's.
Honorable Bongo, Honorable Ross, and Honorable Modise.
No, thank you, Chair. I think that having deliberated thoroughly on this one and having had presentations from the NGOs, it will be a proper legal drafting that the DHA brought, that it should be after consultation. So if it reads like a president acting on a resolution of the National Assembly, obviously it does take care of the entire consultation. And I think acting on a resolution of the National Assembly make a perfect legal drafting for clarity on this one. Thank you.
Thank you, Honorable Bongo. Honorable Ross.
Thank you, Chair. Our understanding of the DHA's inputs in our last session was that they were essentially withdrawing this clause, and so the clause will be as it currently is in the legislation. So that is our understanding of this, Chair. Thank you.
Thank you very much, Honorable Mudisemta.
Thank you, Chair. I think for me, Honorable Pillay and Honorable Bongo's views were sufficient, and I'm in support. Thank you very much.
Thank you very much. Other members could carry Mr. Sanma. Yes.
Thank you, Chair. I'll move on.
Yes, I think we've carried the submission drafting that the IEC and DHA has recommended to keep the formulation on how they've drafted it. Yeah, you carried it properly?
Yes, Chair.
Okay, you can proceed.
Okay, then clause 29. Yeah, just referring here again back to clause 7, so that they both refer to the same funding formulas and limits. Both the proportional allocation formula and as well as the upper limit of donations and the disclosure limits. So then the submissions were that they call for the submissions calling for the retaining of the existing formula and rejecting the amendments. So the existing formula is 60, 2/3 and 1/3, and that inconsistencies between the proposed amendments in section 24 and schedule 22, since they may contradict the original intention of the other sections. Proposed amendments to regulations 7 and 9 of schedule 2 should be rejected. That again referring to the upper limits of donations and the disclosure limits. They propose that amendments to the regulations make no mention in consultation the President is required to have with the PC on Home Affairs and Minister, which is contradictory to clause 6, which we just discussed. That there should be consideration of the particular state capture context in the country, and that the disclosure threshold of 100,000 Rand and a maximum donation of 15 million Rand from a single donator should be lower to what most countries consider, which is between 150,000 Rand and 2 million Rand in terms of upper donation limits. There should be a review of the practices around public funding of political parties to develop a policy framework, and that section 29(2) could be replaced with 100% proportional rather than 90%, and that or the deletion of clause 29(2) from in its entirety. That's another proposal, and the proposal that every independent candidate who wins a party seat gets 0.25% of the funds per seat they occupy, rather than a formula of 67-33. And that provincial legislatures, the MPLs will determine the split. If there are 50 MPLs, each independent MPL would be allocated 2% of the funding available, and each party would receive 2% times the number of MPLs for that party. So the DHA agrees that the last suggestion is a better one, in that it doesn't result in a negative unintended consequences of the 2/3, 1/3 split, and it takes care of concerns raised during the 90-10 split. The IC believe that because of the entrance of new players in the political sphere, this is actually consequential, and the committee therefore must deliberate on the matter in each finality. Smaller and independent representatives are likely to be adversely impacted, and this might raise discontentment, leading to possible court cases on the matter. The rationale behind the change of the equitable percentage will be left on the DHA to advise. So I think essentially the IEC, they're calling for a return to the 60, the 2/3, 1/3. And then legal services is that this is a substantive amendment, and that amendment reverts to the original formula. If the changes unfairly discriminating against independent representatives or smaller parties, the committee must be mindful of the Harkman versus Lane case, where the provision differentiates between people of or categories of people. If so, it does not bear rational connection to the legitimate government purpose. But Chair, I can also I see the hand of Chairperson of Commissioner Love. So if she can perhaps add before members continue. Thank you, Chair.
Mr. Adams, you have a difficulty because you requested to present the document, and I want to question you because you will put the IEC in a corner or any other stakeholder in a corner if you want to invite them at the point you think they must comment. It's important to allow the proceedings and get the views of members. I'm just questioning you so that the IEC must not fall in that trap. And now that you have invited them, let me allow Commissioner Love to comment.
Chairperson, thank you very much. It's not so much a comment. I apologize, Chair, but I had put up my hand because I think that what was being presented here was not a correct reflection of what the Commission is saying. I think the Commission is saying the introduction of independent candidates who will become independent representatives indeed can create differences in relation to the distribution of the amounts from the two funds. And so consequently, the Commission is saying, indeed, this clause is something that is consequential. That is all that the Commission is saying. Regarding how the committee decides to deal with it, whether the committee decides to keep the same formulation, to change the formulation, anything that the committee decides, the Commission has got no position on that. All that we are saying is that it is something that does arise from the introduction of independent representatives. Thanks, Chair.
Thank you, Commissioner Love. Members? Mr. Matonsi, is there a hand?
Yes, yeah, I have here Mr. Swart, and then I'm just checking the others. And then Mr. Ross. Yeah, those two, Chair. And Advocate Bongo.
Thank you very much, Honorable Swart.
And
Thank you,
myself,
Chair.
Chair.
Thank you, Chairperson. Obviously, we will need to deliberate on this clause. This would probably be the most controversial clause. And there seems to be there will be different views on this, but I think the key aspect here is whether it is a substantive amendment. First point, or consequential, now we know Parliamentary Legal Services says it is a substantial amendment. The second issue is that the test in Harkson versus Lane has not been addressed by the department. The consequences and what we as the ACDP would say is the discrimination against smaller parties. Chair, I'm not going to deliberate on this now. I just want to raise this because I know there'll be a lot of deliberations later. But I do think that the committee should seriously consider holding this over to the next administration, given the fact that the IEC has indicated that there is a likelihood of litigation, given the fact that smaller and independent candidates will be adversely impacted. There's a second issue here that we need to consider, and that is Parliament passed the Adjustment Appropriation Bill on the 6th of December, which allocated the additional 300 million. The minister indicated that would only be made available in May. The question then arises, will it be on the new formula, should it be signed into law by then, or the old formula? Clearly, it would be grossly unfair if it was on a new formula of 90-10, when Parliament allocated that money in December already. So there's a lot of debates around this issue, Chair, and I'd like to indicate that our preference would be that this is held over to the next Parliament, or secondly, that we stick with the existing 66%, 33% until we know how many independent candidates are elected. Then one will have a much clearer idea, because at the moment we know we've got single member parties already, and that this was fully canvassed in the previous Parliament when we reached the requirement of equitable, not only proportional, but equitable. Thank you, Chairperson, for these introductory comments. I'd like to deliberate with your permission at a later stage on this issue.
Thank you very much, Honorable Swartz. Honorable Ross.
Thank you, Chair. Just to reiterate the DA's position on this, certainly we believe that what would constitute a consequential amendment would be if you added independent representatives to the group of stakeholders between which the fund should be divided. I agree with Honorable Swart. An independent is essentially no different from a one-person party in terms of how funds would be allocated. You're allocating it to a seat, essentially. A substantive amendment is changing the percentages. Because here, we also need to consider, Chair, that to get to this let's call it the latest split, an entire special committee was formed to go over everything, to deliberate over time, and to come up then with this proposal. So it's just, it doesn't make sense to now come with a spreadsheet and say, well, this then proves that what was said then is invalid and we should change it. So, Chairperson, we need to have a proper review and report on the Political Party Funding Act and its impact. And then one can consider this properly. It needs a proper deliberation with proper public participation based on a proper report from which you can develop a proper policy. Thank you, Chair.
Thank you, Honorable Bongani Bongo, Honorable Pillay, and Honorable Modi Simpson.
No, thank you, Chair. I think we've already had the public participation, and I'm sure in our last meeting we did indicate that and thank all those NGOs because they have enlightened us about whatever we needed to as legislators. It's time now to make sure that we go properly. I'm just happy that at least the IEC has cleared the air in support of the department that it is consequential, and I always held the view that this will impact on the substance, but it is consequential because we're dealing with issues of allocation. And from where I'm sitting, I think it should be allocation per seat. And if you do allocation per seat, you will know that the spreadsheet, which was already provided by the department, makes a lot of sense. I just want to agree with the department that we should go at 90-10 because the 90-10 makes a lot of sense because it is calculated per seat. So it is, in my view, scientific and objective, because if you do these things per seat, you will forget about smaller parties, bigger parties. You will be smaller or bigger because of the number of people your number of MPs you have. But in this instance, if we deal with this thing per seat, it will give you the 90-10. And I think we should go with that. And I'm just happy we have now clarified the consequential, that this is consequential because it has to do with the allocation itself. I see legal services says it is substantive. It may be at the border of substantive because we will have to change, but it's consequential because we need to cater for the independent candidate. So I strongly feel that we must go with this 90-10 as it is, Chair. Thank you.
Thank you, Honorable Pile.
Thank you very much, Chair. Chair, I fully concur with the submissions made by Honorable Bongo, Advocate Bongo. And I want to agree that, yes, when you start off with having to allocate funding per seat, and then you take care of both of the submissions, I support the 90-10, and I think it's adequately covering for both proportional and equitable. And in Chairperson, in light of that, we fully support.
Thank you very much, Honorable Pile. Honorable Mdisemza.
Thank you very much, Chair. I'm also strongly in support of the DHA with regards to the inclusion of independence is consequential on this issue of party funding and distribution thereof. And I'm in agreement with Advocate Bongo and Honorable Pile on the 90-10 split, as it satisfies the Constitution with regard to being equitable and proportional. So for me, Chair, that is sufficient, and the 90-10 makes sense. It may not be 100% accurate, but it is at least satisfies, or it is closer to achieving proportionality and being equitable. Therefore, I'm in support of 90-10, Chair. Thank you very much.
Thank you. Any other comments? None. Thanks. We do note the different views expressed on this subject matter, and it's more clearer that these clauses consequential need to be carried. There was sufficient work that got into the formula that was presented by DHA, and it's a view that is dominating to this meeting to carry and change the formula, given the reasons that members have submitted, and also that there's a new entrance of independent candidates that obviously will shift the allocations of funds that necessitate the change of the formula. And in this regard, the expression that has been put across is to carry the new formula that is presented by the DHA of the 90-10. And I think that it should be and I agree with the Honorable Swart that is a continuous discussions that obviously there will be different views that have been expressed on this subject matter, given its historical how it has been introduced in Parliament. It is the first period of time that the new independent candidate participate in both the provincial and national elections. At this stage, you may not have capacity to know how many will be participating in these houses. But it's important that at that particular time, the formula, Parliament could have considered a formula that also will cover the independent candidates in the provincial and national Parliament. We are carrying the 90-10 given the reasons that has been moved by members. Mr. Adams?
Thank you, Chairperson. We move on to clause 38, which deals with the Electronic Communications Act in terms of the allocation of time.
Chairperson? Chairperson is Mama Bolo.
Sorry. Honorable Mr. Mamawolo.
Yes, Chair. I just want to check with the committee. In item 7 and regulation 7 and regulation 9 of schedule 2 makes reference to parliamentary resolution. I just want to check with the committee whether is that the intention, or whether they want to act in terms of the resolution of the National Assembly as against both houses of Parliament. I just wanted to be sure that the committee is purposeful regarding that aspect on regulation 7 and regulation 9 of schedule 2. Thank you, Chair.
The understanding, Mr. Mamabolo, is that it will be carried by the resolution of the National Assembly. Because if it says Parliament, it then involved the National Council of Provinces. So it should be, the ruling should be National Assembly. That is an understanding of the committee. Unless we are reading from the Mr. Adams, unless we are reading from the wrong space. Is that clarity that you sought? That is an understanding of the committee, Mr. Mamapolo.
Yes, Chair, it's clear. I understand now. Thanks.
Are you comfortable with that space?
Indeed, Chair.
Okay. Thanks.
Before you continue, there's a hand from Advocate Bongo.
Okay, thank you, Advocate Bongo.
No, thank you, Chair. I think I raised the hand, but you properly and adequately summarized it, that we should be clearer that and why I them that it's the National Assembly, not both, not Parliament, it's going to be on a resolution of the National Assembly, which means that it's the committee that is going to deliberate and pass a resolution, National Assembly, and then it will be carried through to the executing authority to make those necessary regulations. Thank you.
Thank you, Honorable Bongo. We can move, Mr. Salmo.
Thank you, Chair. The clause 38 deals with the broadcasting for political parties and independents, and the Department of Communications indicated that they agree that amendments must be made to the Electronic Communications Act on the extent of including independent candidates and independent representatives in line with the Constitutional Court judgment. And the DH agrees with the suggestion to include independent representatives as part of this clause. The IC indicating that ICASA should have a view on this, but we got the official response from the Department of Communications. So they're in agreement that this clause be brought into alignment for independent representatives and candidates. Thank you, Chair.
Thank you, Mr. Salmon. Members? Mr. Matonzi?
Yes, there's Honorable Pillay now.
Honorable Pillay?
Chairperson, I think this is also fairly straightforward, that we have to include them, and that's basically it. Thank you.
Thank you. Any other comment? And there's no any other comment. We carry it. Can you proceed?
Thank you, Chairperson.
Technical proceed.
Thank you, Chair. This is funding of represented political parties by legislatures, which is in section 23 of the PPFA, which is not included in the current bill. And it stipulates the responsibility of the accounting officers to report annually. And there isn't reference to the mention of independent representatives. And the section 23, not amending section 23 would exclude independent candidates. And that funding of representative political parties other than through section 57(2) and 116 of the Constitution in the New Nation judgment that do not negate the possibility of independent candidates participating in the National Assembly and provincial legislature, and in turn refer to independent candidates. Therefore, section 23(2) of the PPFA should be amended to include independent representatives. And the legal services, IEC and the DHA agree that section 23(2) on disclosure of section 57(2) and 116, the Parliament and legislature allocation should equally apply it to independent representatives as it does to political parties. Chair.
Thank you, members.
Chairperson.
Honorable Pillay.
Supported to include independent representatives.
Noted. Any other comment?
So we support that it should include the ISIS. Thank you, Chair.
Thank you, Honorable Disemta. Can you proceed? Carried.
Thank you, Chair. The next section is section 27 of the Electoral Act, which is not in the bill, and which refers to the form in the case of a registered party not represented in the National Assembly or provincial legislature, confirming that the party has submitted in prescribed manner the names, identity numbers, and signatures of voters which appear. And this relates to the 15% quota required for new political parties. The submission we received from the DHA was that the department and the IEC have filed explanatory affidavits to assist the Concourt in arriving at a fair decision. We therefore advise Parliament to process the bill and allow the court to take its own course, whether to make new political parties and independents the same in terms of signatory requirements. So the question there is really, do we make new political parties the same as independents, or do we wait for the court case to say that that new political parties must be the same or different from independent candidates? Thank you, Chair.
Thank you, members.
You have Mr. Pillay, Chair.
Honorable Pillay.
Chairperson, I agree that we cannot preempt the processes of court, and in light of that, we should leave it to remain until that process unfolds. Thank you.
Noted. Any other member, Mr. Matonzi?
There's no other hand that I can see.
Okay, thanks very much. We'll carry it as proposed by the three stakeholders, and Honorable Pillay seconding it. Can you move to the second one?
Clause 31, voting if not in the area where you were registered, which is included, which was clause 31. The submitter is saying that why is the voter not permitted to vote for regional seats and provincial legislatures in another voting district if they aren't on the voters roll for that province? And question whether a redraft may be necessary, the use of using the word or rather than using the word and rather than the word or. So Parliament Legal understood that the purpose of this clause was that the allocation of seats per region is determined by the registered population in a region. It follows then that only voters in a region may influence the outcome of the election in that region. However, greater consideration should be given to the submitter's concerns regarding the drafting of the section. The IEC's suggested reformulation would be that provided that such voter may only vote in the election for the regional seats in the National Assembly in terms of Section 1A, and deleting or and saying and for the provincial legislature if that specified voting district is situated in the province within which the voter is registered. So taking out the bold and adding in the underlined. Section 24A is no longer available for application at voting stations. It's now only available by pre-notification by a date regulated in the election timetable. The voter must indicate that other voting station at which their vote will be cast. In the circumstances, it's no longer necessary to keep surplus ballots at 23,000 voting stations. So there's this addressing a concern around the cost of this provision. Thank you, Chair.
Thank you, members.
What Mr. Pillay?
Honorable Pillay.
Thank you very much, Chair. Chair, I think the presentation made by the IEC extensively covered the logistical challenges that the IEC will face in respect of this, in that you cannot then just have surplus ballot papers at all voting stations. And that by way of only making a special application, then only it will be allowed. It also then allows for a free and fair elections, in that you cannot have people from KZN voting for a seat in the Gauteng legislature. So I think that this sufficiently covers it and that it should be supported. Thank you, Chair.
Any other member?
Mr. Mukhale, Chairperson.
Honorable Mukhale.
Thank you very much, Chairperson. I think there were a few comments that came through during the public, consultation process dealing with this particular section, which I want to agree with, Chair. One of the things that was raised that this particular clause is quite draconian because it has the potential to disenfranchise quite a number of people who may not necessarily comply with that notification process that they need to follow. They will be deprived of voting, casting a ballot, even for national ballot because of this particular clause. So I think it's not something that we'll support, Chairperson, because we want people to be able to vote. Yes, we want people to vote at voting stations where they reside, but to have this particular clause is going to, I mean, people move because of work, because of other issues. They are going to, some of them, they don't even, are not even aware that there's this changes in the Electoral Act, which is not going to allow them to vote outside of their VD. So we are going to find ourselves with a number of people presenting themselves at voting stations and being turned away from even voting on a national ballot, which will be grossly unfair, Chairperson. So there's something that we are not going to support. Yes, the IEC has legitimate reasons. I mean, I understand with particularly issues of the number of ballot papers that they will have to keep at voting stations and so on. But I think this is something that we need to rethink, Chair. We seriously think we need to relook this particular clause so that it does not have an adverse unintended consequence of disenfranchising ordinary voters who may not have complied with that notification process. Thank you, Chair.
Thank you very much. Is there any other hand?
No, Chair.
Chair,
Honorable Mudisemsa?
I think it really the issue raises a lot of concerns. I would want to propose or suggest that we defer this matter to later discussion so that we can thoroughly engage on the issue. Thank you, Chair.
Okay, thanks very much. Let's take note of the submissions that were raised by Honorable Pillay and Honorable Mokhale. And I think we must find consensus as the Honorable Mudisi raises. I'm persuaded to that view that let's defer this clause for further consultation, but also to look on these two options that have been presented in line with what the IEC is raising. What is important is that both Honorable Mokhale and Honorable Pillay fairly agrees with the principle laid by the IEC in terms of this process. But I fully agree that let's defer for further consultation to later deliberation. Is that will be our understanding, Mr. Adams?
Noted, Chairperson. What we can also do is we can give two formulations of the based on the inputs, and then members can agree which one they need or not. So given the progress we're making today, we can provide it by this afternoon already, and also we also have the possibility to consider continued deliberations tomorrow morning if we need to. Thank you, Chair.
Okay, thank you, Mr. Adams. Let's move to the next clause.
There's just an indication of submissions of the aspects in the Electoral Commission Act that were omitted, and that these should be rectified, namely Section 62B, D, Section 9, Section 20, and Section 23. Parliament Legal agree that those references should refer to that where correct, they should also refer to independent candidates, but where they refer only to political parties, that they should remain as such, because there are some places only political parties. I see specifically indicating that Section 62B must be amended to delete the words party political and replace it with a word political to clear that distinction. So that's a clear indication there, Chair.
Thank you very much, members.
Agreed, Chairperson.
Thank you, Honorable Pillay. I think it's clearer. As carried, can proceed.
Yes, Chair. And then there were further submissions on the Electronic Communications Act, referring to 57(1), 2, and 3, and all the remaining clauses there. And that these additional clauses also need to be amended in the Act, and they referred to by the Department of Communications and Digital Technologies, saying that the definition of election period means period commencing with the date on which the election day is proclaimed and ending with the day immediately following the day in which candidates of any of the political parties are declared elected. So it should also refer to independence there. Party election broadcast means a direct address or message broadcast free of charge for a broadcasting service, which is intended or calculated to advance the interest of any political party. So again, reference there needed for reference to independence. And political advertisement means an advertisement on broadcasting service intended to advance the interest of any political party. So again, we're referring on to political parties. So these are all consequential, not substantial. They're technical amendments that are needed for the Electronic Communications Act that were an oversight in the original bill. Thank you, Chair.
Thank you, members. Can we proceed to the last one, Mr. Adams? I think these are clearer.
The bill also in the Financial Management and Parliament Act next to make consequential amendments to 65(1)(f), which speaks to the regulations relating to the funding of political parties. So the suggestion there is to just include section amendments to section 65(1)(f) to include independence too.
Members?
Supported, Chair.
Honorable Pillay?
Supported.
Supported.
Agreed, Chair.
Thank you, Honorable Mukhale. Thank you, Honorable Mutisemta. Mr. Adams?
Yes, Chair, that's the last that we have. So it's up to you to determine how we proceed. Thank you, Chair.
Thank you, members. Can I check with Commissioner Love if you have any other matter?
Thank you, Chairperson. Thank you, members. From my side, no. I would like, if you don't mind, just to check with the CEO whether anybody from the administration wants to come in. From the Commission, I think we just appreciate all the attention from the committee. Thank you, Chair.
Thank you, Honorable. No, Mr. Mamabul, today you call Honorable. Pardon me.
It's the prophecy will be realized.
You receive.
No, we have nothing to add, Chair. Thank you very much.
Thank you. Parliamentary Legal Services?
Nothing from my side, Chairperson, just to re-emphasize that under clause 29 and clause 7, that there must be certainty that the formulation does not adversely affect smaller parties or independent candidates. Because if it does affect them adversely, then we need to determine what the legitimate government purpose is for that adversely for them being adversely affected. That's all from my side.
Thank you, Kelana, the Chief State Law Advisors.
Thank you, Chairperson. We have noted the deliberations. Chairperson, just to mention that when we do present the A-list, there may be some consequential matters that may not have arisen during deliberations, but are as a result of certain changes being made. Chairperson, that will be brought to the attention of the committee when the A-list is indeed presented. That's all from our side. Thank you, Chair.
Thank you, Director General. Advocate Kumalo.
Thank you, Chair. From the department, we have noted the deliberations of the committee with appreciation. We do not have anything to add at this stage, Honorable Chairperson and Honorable Members. Thank you.
Thank you. Members, we have dealt with all the clauses except the one that Honorable Mutisemta has proposed that we must defer it for deliberations later. And there was sufficient engagement since we've started with the oral submissions and the responses by the departments, including IEC, Department of Home Affairs, Parliamentary Legal Services, and Department of Communication. And I think thus far, the committee has dealt with all the issues that are required for us to allow the chief state law advisors to develop a list that must be considered by this committee. And I think that we're at that stage that we may need to give space for the A list to be developed for finality on these areas that we have been dealing with. There may be, as the chief state law advisor have impressed on, that there may be other issues that the committee may further clarify when the A list is going to be presented. I think that is a process that we've been engaged on when we at that level. Mr. Matonsi, now that there's a matter which is outstanding and the committee is supposed to have proceeded in the afternoon, which is unlikely that we proceed, we may give time for the committee or members of the committee to consult around that front, and we come back to the portfolio committee to deal with this matter. But at this point, the chief state law advisor with the A list. What do you take about or can reconvene tomorrow morning, Mr. Matonsi?
Yes, Chairperson. On that one issue that you just indicated on clause 31, I think we can reconvene tomorrow morning. We had a meeting scheduled, Chairperson.
Okay.
The state law advisors, we have got another meeting on Friday. If they are done with the A list, so that it can be presented to the committee. There is a hand from Honorable Swart, Chairperson.
Honorable Swart.
Thank you, Chair. Maybe I misunderstood the committee because I was under the impression that there might be further deliberation on the 9010, given the fact, and I understand the ANC members did give a preference, and so did the ACDP and the DA. But my concern is still that there are outstanding issues on that matter from a legal perspective when it comes to the parliamentary legal advisors indicating that it is a substantial amendment, and secondly, what is the legitimate government expectation? So, Chair, I need your guidance here, because obviously the ANC is in the majority if there's no further deliberations going to be permitted on that. But I do think that considering that this is a significant amendment to a constitutionally mandated act, which is the Political Party Funding Act. Yes, we can amend any act, but one needs to do it with a lot of circumspection. So I'm in your hands, Chair. If as you indicated, that it seems the ANC majority is going with the 9010, then obviously we would like to just record our opposition to that. But I just wanted to raise this outstanding issue. Thank you, Chair.
The process, if you followed the portfolio committee work to date, we have not elevated political party, minority in the meeting, nor majority. Members of the committee are persuaded by discussions and dominancy of the views objectively expressed, and wider consultations with the stakeholders. In other words, involve the IEC, Home Affairs, and those that are related on the subject matter the committee has been dealing with. So I'm trying to say that we have not at all deliberations since then have elevated DA or say ANC's majority. Therefore, this matter could go through, and I think it is an unfair submission to raise that. The members of the committee, obviously from political parties, express views. Decisions are taken collectively, and we at this far. This is a process that we've engaged in. Decision has been taken on the views. We're noting the concerns, Honorable, not even concerns, we're noting the objection on some of the clauses that we've carried which you're not supporting as a member of the committee attending this meeting, and that we're carrying it. And I think it's the right of any other member who subjecting himself or herself to discussions that have been carried by the committee. Fairly summarized is that all the clauses have been carried by the committee. The only matter that we said members must further go and consult is clause 81 that will reconvene tomorrow to deal with. And I think that is an understanding of the committee thus far that has been we're noting the objection on the formula that have been raised with Honorable Ross.
Chair, sorry, I didn't want to state anything. I just got the impression that that was the opinion that was being put. So I didn't want to cast any aspersions or any unfair aspersions. I thought that given the fact that it appears that deliberations on the formula have come to an end, that it was an opportune time to put one's position, as it seems that there are not going to be further deliberations on that issue. So I didn't want to cast any aspersion. My challenge is, of course, I haven't been part of all the deliberations on this issue. So I appreciate your explanation. Thank you, Chair.
Thank you, Honorable Ross. I also appreciate for having contributed to this subject matter as a committee. We all invite members. If you have realized, we have not even taken a vote, which I think is more credible for the process that we must engage on. Thanks, members. We'll then reconvene in the morning. We're not going to reconvene at 2 o'clock. We'll reconvene tomorrow at 9, noting that there's a sitting tomorrow, Tuesday, and then we deal with the subject matter. The state law advisor, you will then proceed with is that our understanding? And perhaps if you can just assist us with the time frame so that when we are done tomorrow, what time do you need to come back to the committee with the A list, and further opportunity to be given to members to highlight some of the issues that may arise from the A list. Chief State Law Advisor.
Thank you, Chairperson. Chairperson, our original understanding was that the A list will be presented on Friday, based on the fact that there would be deliberations today and tomorrow, and then thereafter we would draft, and obviously we would liaise with the parliamentary legal advisors, IEC, or any other stakeholders that would be necessary. Chairperson, would the committee require us to present the A list prior to Friday?
Well, we're scheduled to have a meeting except on Wednesday, from today until Friday. What we want to ascertain is that time when you can come back to the committee within, if you can come back on Friday, that's still fine in terms of the scheduling.
Yes, Chairperson. We will be ready on Friday. If there is a need to, you said we're not sitting on Wednesday. If there's a need to bring the meeting forward to Thursday, if that is a request from the committee, then we will definitely endeavor to have the A list ready by then. But as it stands, for Friday, we will definitely be ready. If it is required that we come bring the A list a day forward, we will also endeavor to do that, Chairperson. We will leave that to the Honourable Committee.
No, I appreciate it. I think that we'll communicate that tomorrow in our when we finalize this meeting. Thanks very much for that. Is the contrary view want to be expressed, Mr. Matonzi?
There's a hand from Advocate Bongo Chair before.
Okay, Advocate Honorable Bongo.
No, thank you, Chair. My view is that now that we've done this work and we're supposed to do some work after afternoon, and we're no longer doing that. If the parliamentary legal it's ready anytime, including tomorrow or Thursday, because it will be in the interest of the time and in the interest of the whole process of the IEC, that we frustrate this process. We move with a much better speed. So if they can be ready with it either tomorrow or earlier than Friday, it will be appreciated that we get that, so that we push the process with the necessary speed that it needs. Thank you.
Okay, thanks very much. Noted. Let's in principle agree that let's deal with the A list on Thursday. Yeah, on Thursday, let's bring it closer. Thanks very much, members. Commissioner Love, thanks for having attended with your guests. We're appreciating that they will also input in your deliberations in the visit. And I think they've noted that this is a new legislation in our new democracy that we're grappling with in Parliament since the last sitting. But I think it's in the spirit of being transparent regarding the financial arrangement within the political parties, and now with the new regime of the new independent representatives or candidates that will find expression in both or in the provincial legislatures or houses, and also in the National Assembly or in Parliament. And I think within that spirit, that Parliament or committees are grappling with this subject, but commitment of contribution from various political parties is what is important, but also taking into account our NGOs, stakeholders, who from time to time, before legislation be passed in Parliament, there's a thorough consultation with our people since we've started this process. That's to appreciate how far we've gone through with our stakeholders and political parties to this end. We really appreciate and also noticing, giving notice to the committee, Commissioner Love, that you have guests that are also have experience on this subject matter. Wish them well with their visit and also deliberation to enhance the work of the IEC, and hope that also the lessons that the IEC will demonstrate to them. We know that benchmarking, part of the strengthening institution is benchmarking and learning from one another. So I want to thank you for inviting them to the session. I'm not sure whether I want to give a word to Commissioner Love on behalf of the IEC, just to indicate with your guest.
Chairperson, just to say on behalf of the Commission and on behalf of our guests, I want to thank you and the honourable members. I think that the discussion and the issues raised in have concerned political party funding, and of course are of particular interest. But also I think just the fact of having the robust interaction and the transparency is also something that is deeply appreciated, not only by ourselves, but also by our guests and those who come. And we will hope to learn from our guests, and we'll be sure to feed that through to the committee at the relevant time. So thank you very much, Chairperson, also for the generosity of the committee in enabling the Commission to have our guests present in your deliberations. Thank you.
Thank you very much, colleagues. And I think, Commissioner Love, they must not be surprised that all members have grounded their cameras because of difficulties of load shedding. And I think that's important for members to be able to participate. Thanks very much. Our meeting stand adjourned.
Chairperson, before you adjourn, there was a hand from Ms. Kanyile, but she dropped it.
Thanks very much. Our meeting stand adjourned. We'll reconvene tomorrow at 9 o'clock. Thanks, members.
Long live
Thank
the chair.
Thank you, Chair.
Bye.
Thank you, Chairperson.